that he was a person that should not be trusted, that the veracity of his statement should be questioned?
That would have been a mistake on my part to allow him to be a training officer. Absolutely.
But if he had been a training officer during those last years of employment leading up to his resignation in 2013, given that position, shouldn't the officers that served under him as trainees believe that, look, this is a guy I should view as a role model?
He should have never been put in that position, and if he was put in that position, then that's a mistake on my part.
But in the trainees who were under him, subsequent to his reinstatement up until his resignation in 2013, given the fact that this guy was being held out as an FTO, wouldn't you agree that the officers under him, being trained by him, should view him as a role model? This guy knows his stuff. He knows what he's doing. We should in many ways craft our behavior as police officers around what he does as a police officer.
Well, I wouldn't go that far. I would say that if he was put in a training position, that was a mistake that I should have caught and corrected. I'm going to refer back to there's a point in time in my career I had training officers that you were like, I ain't doing that because I ain't going to jail, you know. So,
all right, but can you at least agree with me that a trainee should reasonably infer from the decision by Daytona Beach to put Ram in the training role as FTO? They should infer this guy knows what he's doing. He knows what he's talking about. We should follow his lead.
Reasonably, yes.
Okay. All right. Now, are you familiar with any of the lines of cases that state that police officers may use force, reasonable force, of course, on a subject who's in the act attempting to destroy evidence?
Reasonable force, yes.
So it was not inappropriate for Mr. Booth to at least put his hands on Miss Chippewa and we disagree on what he should have done after that, perhaps, but it was appropriate for him to at least put his hands on her head to try to control it in order to help prevent her from destroying the drugs that were in her mouth.
I agree with you.
Now, was it appropriate for him, in your opinion, for him to put his fingers on the outside of her jaw like this and attempt to keep her jaws from working up and down so she could chew and swallow the dough?
I agree with you.
Okay, so that was appropriate. Okay.
I agree with you.
Okay. Now, so in your mind, there were two things that were inappropriate. This was appropriate for him to hold her jaw open and forcefully to pinch it, essentially to keep her jaw open. It was appropriate for him to hold her head on the ground, yes?
Yes.
And to keep it so that she wasn't able to turn away from him. Hold her hand forcibly to the ground, correct?
Correct.
Okay. Now, where we disagree is that you indicate that he should not have put her fingers in his mouth. Or he should not put his fingers in her mouth, correct?
The fingers in the mouth and the flashlight, I think, is where we're disagreeing.
Okay. All right. So.
But the flashlight is the excessive force portion of it. I mean, if you want to stick your fingers in somebody's mouth, and I can testify to that, you might lose it.
So you don't think the fingers in the mouth were excessive force?
That I could have dealt with the fingers in the mouth as not being excessive force. That's something we could have corrected.
Now, have you ever done that as a police officer? Put your fingers in
not intentionally, but close enough that where they latched onto it and almost bit it off.
Fun. Okay. So the flashlight then. So the flashlight is what you consider to be the excessive force that Mr. Booth used on the scene of this arrest.
Yes.
The sole use of excessive force at the scene of this arrest.
No. The knee strike to the head or kick to the head or whatever term you want to use. Whether it's a knee, whether it was a kick, whatever it was.
All right. I'll come back to that in just a second. Now, did you ever, I can represent to you that Sergeant Savitsky, strike that, I can represent you that Sergeant Creamer, nor anyone else with IA, ever asked Mr. Booth directly how long the flashlight was in Miss Chippewa's mouth. Did you ever ask him that question?
I did not.
Don't you think it's a relevant one to ask?
I it all depends. I was looking at the video, and what I saw on the video, and when you look at the totality of the events, it was excessive.
Okay. Don't you think it's an important question to ask when you're looking at whether or not the use of the flashlight was excessive force to understand how long the flashlight was in her mouth? Because if it's 2 seconds versus 20 minutes, it's obviously a wide value there. Would you agree?
I would agree. It's a question that we should have asked.
Okay. And so it would be less likely to be excessive force if it was in 2-3 seconds versus versus 2 minutes, 3 minutes, 5 minutes, 10 minutes.
I disagree with you. I think inserting a flashlight into somebody's mouth is excessive force, whether it's for 2 minutes or 20 minutes or 2 seconds.
Is there any evidence that you're aware of that specifically indicates that Ms. Chippewa was caused injury by the insertion of the flashlight?
I believe she had dental work, if I remember the lawsuit correctly.
Oh, if you were here when she testified this past time, correct?
I was.
And I asked her, I think, the question whether or not she received any type of dental care as a result of the arrest, and she said she couldn't afford it.
She couldn't afford it, I remember that.
Okay. So are you aware of any medical evidence that she sustained any injuries to her mouth as a result of the insertion of the flashlight?
I do not know the answer to that.
Okay. Now, you said repeatedly the flashlight was forced into her mouth. Now, isn't it true that Mr. Booth testified in his IA statement that he simply slid the flashlight in without resistance?
I found that pretty incredulous.
Okay. Do you have any reason to dispute it or to discount that testimony?
Can we do a test case somewhere? I'm just going to allow you, no, neither one of us, but are you just going to allow you to slide a flashlight into my mouth, but at the same token, I have to use force to hold her head down from flashing around. It doesn't, thrashing about.
If he had shoved the flashlight in her mouth, don't you agree there would have been perhaps a chipped tooth, a broken tooth?
That's what my understanding is there were from the police reports, the IA reports, that's what there was.
But there's no medical evidence to support any of that, is there?
Not that I know of.
You heard Ms. Chippewa say that she didn't receive any treatment for any dental injuries.
I think because she couldn't afford it, is what she said.
Now, and no photographs were taken, to my knowledge, and if you have different information, let me know. No photographs were taken of any broken or chipped teeth, correct?
I don't know.
Okay. So you're not able to sit here, you're not able to testify there was, in fact, any particular injury that resulted in the insertion of the flashlight. I
can't testify that I saw any medical documentation. I can only go by what the interviews stated.
Okay. Now, did you watched the video of the second encounter? I'm sure. Yes.
Yes, sir.
I probably watched it more often than I like to admit. Did you notice that during the course of that second video, that Ms. Chippewa never complained about a flashlight being in her mouth?
No, she consistently complained about the kick to the head.
Okay, but she didn't testify. She didn't complain about the flashlight.
I don't recall that.
Okay.
She did.
Okay. Now, you would think if a person had the flashlight shoved in their mouth, that would be something they'd be very vocal about at the scene of their arrest, right?
Unless the pain caused from the kick or knee strike or whatever term we want to use to the head was what was more painful. Or, that's what she kept saying over and over and over again to anybody who would listen, was he kicked me in the head.
You guys think the other possibility is that the flashlight didn't seem that big of a deal to her at the time.
I object, cause for speculation.
Do you have any evidence that Mr. Booth was trying to hurt Ms. Chippewa when he inserted the flashlight in her mouth?
No.
Any suggestion he was acting with malice or being punitive or trying to punish her in any way?
I can't answer that. I don't know. I don't know what was in the officer's mind.
What was your understanding of the reason that Mr. Booth inserted the flashlight into her mouth?
To recover the bag of drugs.
So that he was acting with a law enforcement official.
Well, on the 13th, that's what he was acting with, to recover the bag of drugs. On the 17th is when the internal investigation began, is when we had this, Mary had a little lamb story of, we are now going to save her life because of what happened in 2005, which I'm sure Mr. Booth didn't know about this alleged Mr. whatever. So the story continued to morph as we went deeper into this.
Well, I've got to ask you then.
Go ahead.
What is this theory you have about the morphing of the story from drifting to
Because all the original documents were making an arrest and we're trying to recover drugs. Then when we discover there's an internal investigation, 4 days later, there's a supplement prepared by Mr. Booth to try to explain why the camera isn't recording this incident. And Officer Booth prepares a report that says, oh, I watched him turn it on. I don't know what the exact verbiage is in the report, but he basically says there's no way it couldn't have recorded because Officer Random turned it on. Then we terminate Officer Random, or terminate him. He resigns and says, I turned the camera off. I'm resigning. I'm not going to face the consequences. Here's the thing. So we know that on the 13th we had this incident. On the 17th we have a report filed trying to document why specific items weren't done. And then we go to the IA interview. Oh, I was trying to save her life because this guy Bostic died in 2005. You would think all that would be put in your initial report. You don't think that a month and a half later, after you get the entire package to review before we interview you, where now we need to fill in these gaps. In 2005, this happened, so tell them that.
Not every single detail of an officer's motivation goes into an incident report.
You're correct, but however, if I am saving somebody's life, if that's the whole crux of it, I had to do it to save her life, that would be in my damn original police report. That wouldn't be 6 or 8 weeks later when after you're given the IA, or whenever the IA is done, and now it's your turn to respond, well, you get all the evidence. So sure, we're going to sit down and we're going to fill in the blanks. How about this 2005 case with this guy in Tulsa? You were trying to save her life.
Do you have any suggestion that any evidence that Mr. Booth was led to testify in that particular
I'm not saying that Mr. Booth did any of that.
Do you have any evidence at all that Mr. Booth wasn't trying to save her life?
I can only go by what the initial...
Let me ask the question, and you can answer it then. Do you have any evidence, other than your supposition, that Mr. Booth was not acting, impartially at least, to save her life when he took hold of her head and undertook other actions he undertook on the night of June 13, 2013?
I have his sworn police statements that never mention that. Do you think that that's a critical thing you would mention?
But we've agreed that not every single motivation behind a police officer's actions needs to be put in.
You're correct. Report. But a critical piece of information is, I was saving so-and-so's life.
Well, at the point, it may not seem so critical, correct?
I would think it would, because that's what we transported her to the hospital.
Well, there were dual, once you agree there are dual reasons at play here, according to Mr. Booth. A, prevent the destruction of evidence, and B, protect her life. And
both are extremely important. If you are doing something that is completely out of the realm, completely out of right field,
just like
inserting a flashlight in somebody's mouth, that's something that I would want to put on there. That's something I would put that use of force report. I use this force to do that. There is no mention in any police reports about inserting a flashlight in.
Well, it reminds me of your notice of termination, because you said that a big piece of the reason that you terminated Mr. Booth was this conspiracy between Random and Booth, this conspiracy to cover up whether or not the camera was on or off, and you said that was an important factor, but yet that wasn't in your notice of discipline, correct?
Mr. Random.
So these mistakes happen, yes?
Wait a minute. Mr. Random was gone way before I served Mr. Booth with his termination. Mr. Random was gone in July of 2013. I didn't terminate Mr. Booth until 2014.
But Mr. Booth was a co-conspirator in this conspiracy to conceal evidence,
absolutely.
Correct? But yet you didn't include that fact, or that allegation, and you didn't include any mention of this supplemental report when Mr. Booth states that he saw Mr. Random turn on his Axon video camera. You didn't include that in your hold on. You didn't include that in your notice of termination.
It's all in here.
Well, hold on. Excuse me,
it's
sir.
All here, Councilman.
That was an important fact, wasn't it?
And it's in here.
It's not in your February. It's not in your notice of termination.
Councilman, it's in here. It was given to everybody. Here it is. This book contains everything.
Let's back up a second. You'll go back to the exhibit I initially marked as Union 3.
You're right.
That's your notice of termination.
You're exactly right.
We've already gone through this.
We have.
That you did not mention anything about this conspiracy between Random and Booth and Axon video camera anywhere in that, even though it was a major piece of the support that underscored your termination of Booth, correct?
It's not in here. However, when your client was terminated, he's given this, he is given a copy of this.
Well,
He's given everything.
Don't you agree, sir, that he should be able to assume that whatever is in your notice of termination, it outlines all the bases for his termination?
It outlines the reason for termination, and all of the evidence supporting that is in this book.
But in your document, I trust that your intention was to give him the specific bases for your decision to terminate him, the pertinent factual allegations, and also the details surrounding what particular violations.
It's a synopsis of what happened, and plus he is given every
It's a synopsis
interview.
now.
That's what it is. This is why he was terminated. It's right here. I don't even know how many pages this is. So you condense this into this.
It's okay that you don't include that brain conspiracy in your notice of termination, but you consider it to be a cardinal sin, and in fact, evidence of perhaps some type of another fabrication on Mr. Booth because he didn't put the motivation to try to save her life in his incident.
I never used the term fabrication. What I said is, after all this evidence is presented to you, now when you come in for your interview, oh, by the way, I was trying to save her life. It's a pretty important thing to leave out of a police report. You're
Just
talking
like
about...
it was a pretty important thing for you to leave facts on video camera and the conspiracy allegation.
This isn't a sworn statement, Counselor. This isn't a sworn statement, okay? It's a synopsis of what is in this book.
Does this say that
you were provided this book?
I'm going to ask Mr. Arbitrator that Counselor give the witness an opportunity to finish answering the question. He's now interrupting the witness.
Well, in fairness, he's interrupted me as well, but I understand your point, and I will attempt, if it's Chief Shotwell will, to not step over each other.
I agree.
Now, I apologize. Just to clear this matter up finally, so we can move on, and we'll probably have to get to Mr. Sergeant Freeman here in a second. You agree that you left an important aspect of the basis for your termination out of your notice of discipline.
We don't agree with that.
Okay. Do you see it in there?
I don't see it in there.
Okay. You did. So you did leave it out.
It is. You can word it any way you want, Counselor, because we'll sit here till the cows come home. Everything that was involved in this investigation is inside this book. Okay. Now, if you want, we won't do this. We'll put from here on out. I'll change the way we do it. Notice of termination. Read the arbitrators. Read the investigation. We'll hand it over. That's the way the union wants to agree.
Is anywhere? I'm not speaking to the union on that point. Anywhere in your notice of termination, does it say this is only a synopsis?
It does not.
Does it say refer to the IA investigation?
It does not.
Okay. So don't you think Mr. Booth is entitled to rely upon that as the distillation, the specific acts that he committed that violated policies that resulted in his termination? He was entitled to rely upon that notice of termination to understand what the allegations were against him?
I would hope that you would rely on what is in here.
Does it say anywhere in your termination you need to rely on what's on that book?
Then maybe we shouldn't supply this anymore. We'll just supply this piece of information, and that's how we'll go forward.
But yet you find enormous fault with Mr. Booth for not specifying in his narrative supplement report that in addition to trying to prevent destruction of evidence, he was also attempting to save a life.
Yes, absolutely. Trying to save somebody's life, absolutely.
Yeah. So it's okay for you, but not okay for him.
I didn't say it was okay for me, Counselor. I'm not the one who shoved the flashlight down somebody's throat and then lied about it in their police reports.
Oh, believe me, Chief, we'll get to that. But now we're going to, I guess I'll conclude for now, have you rest your case, and I'll call Sergeant Kramer.
Briefly, I'd like to move my book of exhibits into evidence at this time. See, you don't have the book that I provided you last time, but I'd like to move it into evidence. I'm not comfortable with that because I've not had an opportunity to examine every single exhibit. He's not taken the time to introduce these exhibits and authenticate them. I don't feel comfortable with that. I mean,
You review them, then I'll make the decision whether to receive them.
very well. Thank you.
Well, with that caveat, and understanding that I want to have an opportunity, based on your ruling, to introduce exhibits, I rest.
Okay. Can we take about 10 minutes?
Sure.
Is that okay, Mr. Prosper?
Okay, sure.
What's your guess? Are we going to finish today? Can
Sure.
we finish by 6-ish? Because, I mean, we can't be in here all night, but do we have a chance of finishing
I
today?
think we have a chance.
Okay.
I think we have a chance.
Do you want to order lunch to come in now? I mean, are you as opposed to break for lunch? I mean,
Yeah.
I don't know what you guys want to do.
I'm not really in love with eating while people are testifying. And we can, I mean, if we're gonna have lunch, we can do something quick, or have it brought in and take a break and eat if you want to do that, but I'm really not in love with eating while people.
Ben and I defer to you.
So,
I'll leave it to you guys. I don't eat lunch, so.
You want to get lunch?
Diet Coke.
so you know where Creamer is, I guess, because I haven't seen, I haven't laid eyes on it. Okay. So you're in communication with them?
Yes.
Okay.
Gary.